Let's move to domestic violence court. Now, folks, I have drafted this particular presentation, not yet bringing into account the very immense and substantial amendments to the Domestic Violence Act, which I believe, if the word on the street is correct, will be coming into operation in the first or second quarter of this year, but nothing more specific than that. So for purposes of this discussion, I have still kept to the Domestic Violence Act pre-amendment, and obviously once the amendments come in, we will have a look at the amendments to the Act. Right. What is domestic violence, folks? Domestic violence is much broader than simply physical abuse. And when one thinks of domestic violence or GBV, very, very often one is inclined to think simply of physical abuse, as it is the most outwardly manifested form of domestic violence. It is one of those things where the evidence is quite easy to see. Door is broken, a window is broken, you can do your forms, your medico-legal forms, you can see the bruises, etc. In a very, very explicit kind of way. However, there are much more, and many more, in fact, insidious types of domestic violence which can be as, if not more, damaging than, and I don't want to say mere physical abuse, but physical abuse on its own. Let's start with the definitions of domestic violence in the Act. Right. Now, the Domestic Violence Act lists various types of domestic violence, and they are as follows. And this comes from the definition of the domestic violence, definitions contained in the Domestic Violence Act, which literally state the forms of domestic violence are 1, 2, 3, 4, 5, and they are physical abuse, sexual abuse, emotional, verbal, and psychological abuse, economic abuse, intimidation, harassment, stalking, damage to property, entry into the complainant's residence without consent, and any other controlling or abusive behavior, which is obviously quite a catch-all, open to interpretation of the parties and or the presiding officer sitting in that particular domestic violence court. Now, what is physical abuse? It means any act or threatened act of physical violence towards a complainant. So it's not necessarily an act, it's not just the physical act itself. A threatened act of physical violence can also be seen as physical abuse. Sexual abuse is very, very broadly defined, very much expanded in the amendments, if my memory serves. It means any conduct that abuses, humiliates, degrades, or otherwise violates the sexual integrity of the complainant. Then we get into emotional, verbal, and psychological abuse. Interestingly, folks, in the amendments, they've replaced the and with an or. So it's emotional, verbal, or psychological abuse. I'm sure someone somewhere in some court came into a lacuna in the law by the use of the word and, but be that as it may, they are changing it to or. Now, very importantly, under emotional, verbal, and psychological abuse is this concept of a pattern. Be very, very careful, folks, when you want to rely on emotional, verbal, and psychological abuse in litigation matters. Always establish a pattern. A once-off event might not be sufficient to satisfy the magistrate who is dealing with the matter. Now, what can that include? It's degrading or humiliating conduct towards a complainant, which may include repeated insults, ridicule or name-calling, repeated threats to cause emotional pain, or the repeated exhibition of obsessive possessiveness or jealousy, which is such as to constitute a serious invasion of the complainant's privacy, liberty, integrity, or security, freedom of security of the person. Now, very, very interestingly, and I am digressing a bit to talk about the amendments. They have very much included in the amendments provisions that deal with this idea of jealousy and kind of limiting a person's liberty, etc., etc. So I think that's going to help quite a lot in the landscape of domestic violence. Then we look at economic abuse, also very, very much broadened in the amendments, but for now includes, number one, deprivation of economic or financial resources to which a complainant is entitled. Karen pointing out this idea of pattern has also been deleted in the amendments, which I think is fantastic, Karen, because I mean, really, if one deals with ridicule, insults, or name calling that is sufficiently degrading to the person, why the hell must they wait for it to become a pattern before getting relief from a court? So good on the legislature in terms of that. Economic abuse, unreasonable deprivation of economic or financial resources to which a complainant is entitled under law or which the complainant requires out of necessity, including household necessities for the complainant, mortgage bond repayments, payment of rent in respect of the shared residence. Now, obviously, folks, here we are treading a bit on the toes of the maintenance court or even the Rule 43 court in certain instances. However, the domestic violence court has a specific provision that these types of orders may be granted and may be granted as interim measures until another court could intervene. And for that, go look at sections 6 and 7 of the Domestic Violence Act. And then finally, under economic abuse, the unreasonable disposal of household effects or other property in which the complainant has an interest, for example, in the context of a fight, throwing your partner's laptop out the window or damaging their laptop, etc., etc. Well, disposal in this case, not damage. Damage to property is lower on our list. Then intimidation means uttering or conveying a threat or causing a complainant to receive a threat which induces fear. See the overlap here, folks, between intimidation and physical abuse. A threatened act of physical violence can also be seen as intimidation. Then harassment, once again, a pattern of conduct, in this case, which induces the fear of harm to a complainant, including watching or loitering outside where they reside, work, carry on business, study, or happen to be, making telephone calls or inducing another person to make calls, whether or not conversation ensues, sending, delivering, or causing the delivery of letters, telegrams, packages, facsimiles, electronic mail, or other objects to the complainant. Stalking means repeatedly following, pursuing, or accosting the complainant. Damage to property means willfully damaging or destruction of property belonging to a complainant or in which they have a vested interest. Entry into the complainant's residence without consent, which speaks for itself, and any other controlling or abusive behavior. Folks, lots of amendments and extensions to these definitions in the amendments once they come into effect. We are going to see interesting new concepts such as old person abuse. We are going to see things like spiritual abuse, removal of some of these problematic various problematic issues which have created lacunas for parties wanting to approach the domestic violence court. And this pattern, in fact, I once acted for a client where the magistrate said, well, there's not a pattern. And our case was, well, the one incident was so traumatic to my client that, why wait for it to happen again? But the magistrate very fastidiously held on to this idea of pattern of behavior. So thank goodness that is going out the window. Guys, be aware these definitions are all open to overlap. So whenever you want to approach the domestic violence court on behalf of a client, and I'm speaking to the attorneys now, Always keep your crib note cheat sheet of domestic violence forms, because very often there is an overlap and you may end up just misinterpreting a specific section if you do not refer back to the Act. In fact, it's always best practice. When dealing with Children's Court, have your Children's Act next to you. Maintenance Court, have your Maintenance Act next to you. And the same with Domestic Violence Court. Now, what is the Domestic Violence Court process? Now, this is a very, very interesting process. If you want to read up a little bit more on it, start from Section 4 of the Act all the way to Section 7 of the Act. That should be your Bible in terms of running domestic violence proceedings. Step 1, an applicant completes a prescribed application form and submits it at court. We'll go through the application form in a bit. Then immediately when they apply, a return date should be set for the hearing. I know some courts don't do it. Some courts just dismiss outright, but that is not in accordance with what the Act says in its present form. A return date should be set, and then the magistrate dealing with domestic violence matters on the day should consider the ex parte application in chambers. Now, ex parte, folks, very important for those who are not legal practitioners. It means that you approach the court without giving notice to the respondent that you are approaching the court. And in domestic violence, obviously, that would be the case. You are dealing with power dynamics, power imbalances. You're dealing with a fear in terms of the abused party. So they have to be able to go to court knowing that they will have some sort of relief in place before the abuser or the alleged abuser finds out about it. Because obviously if you run to court and you have a bona fide domestic violence claim and you need protection, obviously if your abuser finds out about that before you go to court, it can be very, very problematic. Unfortunately, ladies and gentlemen, as most of us know, this opens up the domestic violence court to immense and profound abuse, to the extent where I think if we took a tally today of what percentage of domestic violence court matters are really bona fide, we would come out far below 50%. I once took a tally in a day course that I was doing, about 30 different practitioners, and the overriding consensus between those practitioners was that it's about at the 20% mark, which means 4 out of 5 in their experience, domestic violence matters were frivolously, spuriously, and capriciously launched. Now, I digress, however. What happens when the ex parte application is launched? Well, the papers go to magistrate in chambers. The magistrate in chambers does one of two things. Now, understand, if you go according to the letter of the law, a return date should be set for hearing before the papers even go to the magistrate. So whether or not the magistrate makes an order at ex parte phase, there must be a hearing at a later stage. The magistrate must issue a domestic violence interim protection order if two factors are present. One, there is a prima facie case or first glance case for domestic violence. And secondly, undue hardship could ensue to the applicant if an order is not granted there and then. If the magistrate is not satisfied that there have been acts of domestic violence or that an interim order should be granted, they do what's known as a notice to show cause, and I know it is a dreaded document for various practitioners. If that notice to show cause comes and your client doesn't get their interim order, it is quite devastating to litigants. But in short, what that means is no interim order is granted, and you come back to court on a return date to adjudicate the matter, and the court then decides whether to grant an interim protection order or a final protection order. That is very often more devastating than just having had the matter dismissed, because now what happens is, in bona fide cases, obviously, I'm not talking about the spurious cases. In bona fide cases, the abuser is going to know that the victim has run to court, but they don't have any court order to protect them while they wait for their day in court. So it can be a very, very devastating thing to happen. There are some magistrates' courts who dismiss applications at this stage already, where they look at the ex parte application, they dismiss it outright. I'm not going to comment on whether they are out of line or not. What I am, however, going to say is that is not in line with the wording of the Act as it stands now. One of the amendments which might be a bit bad for applicants in terms of the ex parte is there is now a third requirement that's going to come in, and I think the requirement is something to the extent that it must be in a form to give substantial redress or something odd like that. Then we get our return date. The trial is conducted if the magistrate is satisfied that acts of domestic violence were committed. A final protection order is issued. Right, then we're going to move on to our domestic violence court. I didn't look at the variation or the discharge of the agreement. It's the same as the one where you vary or discharge a court order. This is the current form for an application for a protection order, Form 2. Once again, these are very fact specific. You may need to do an accompanying affidavit. However, I have noticed, folks, if you do an accompanying affidavit, very often magistrates look at the applications that have an affidavit more critically than the ones, ironically, that are just filled in by the parties themselves. I suppose the suspicion comes from if there is an appended affidavit, they think an attorney helped this person and they might be trying to buck the system. So first off, you put your particulars of the complainant, that is the victim of domestic violence, and you set out their name, ID, etc., nature of the domestic relationship with the person who committed the act of domestic violence. This is incredibly important, folks, because there are only certain circumstances where you can rely on the Domestic Violence Act. And that is if there is a domestic relationship that is defined in the Act. If you have a child together, you live together, you are related by consanguinity or whatever the case may be. If you are not in one of those specific domestic relationships, you have to rely on the Harassment Act, Protection from Harassment Act, which is similar but not identical to the Domestic Violence Act. Then if you are bringing the application on behalf of someone else, say for example a friend gets locked up in her house by her abusive husband, they cannot get out of the house, they phone you in a panic and say, please, I need an interdict, go on my behalf, or they are disabled, or they are of a cognitive position where they don't have the capacity to do it on their own, then you can do it on their behalf. And you also have to set out reasons in that case why you make the application on behalf of another person. Then thirdly, the particulars of the person who committed the acts of domestic violence. Number 4 is are there people affected by domestic violence? Very often if a spouse goes to domestic violence court, they would put in the names and the ages of the children if the children witnessed the acts of domestic violence. Very, very sad cases, obviously those, but that is how you would put those in, and then you would set out how they are affected. They witnessed the respondent being abusive towards me, it is traumatic to them, etc., etc. Put in any details of disabilities. If there are any disabilities that are noteworthy, you put them in there. And then you put in the details of the acts of domestic violence. What happened? Were firearms or dangerous weapons used? Were there injuries? Was there medical treatment, etc.? Very much focused on the physical side of it, isn't it, folks? But we have gone through in great length the less corporeal or tangible forms of domestic violence earlier. So you would put your particulars there. Quite a big space. If you do it with a font size of 10, you can get quite a bit of detail in there. Be careful, obviously, in deciding whether to use the form or just an affidavit. Then you deal with urgency of the application. Must the court deal with it as a matter of urgency? I would say most domestic violence matters are fairly inherently urgent. However, set out grounds of urgency very, very fully and succinctly as well. And then you ask for the terms of the protection order that you want. Generally, if a protection order is granted, you will always get an order in terms of A and B, not to commit an act of domestic violence and not to get the help of another person to commit any act of domestic violence. In terms of the question that we had earlier regarding the attorney, I think this would be broad enough if that is ticked to really kind of bring the attorney into the fray, as it were. Not to enter a shared residence, not to enter any specified part of the shared residence. I don't know how one would enforce this, but in any event, you can ask for it. Not to enter the shared residence, obviously a very devastating order that you can get against a respondent in these cases. Hi Doris, thanks for joining us, nice to see you. Then not to enter the complainant's place of employment, namely XYZ business at XYZ or ABC address. Right, then G, not to prevent a complainant or any child who ordinarily lives or lived in the shared residence from entering or remaining. In other words, don't lock us out of our home. And then not to commit any other act, namely shoot for the moon. Not to have their attorney write snotty letters every other day, I suppose, or 7 letters a day type of thing. Additional conditions, these are very practical in nature, save for 2, which are very, very devastating to a respondent. Rent or mortgage payments, which would be under emergency monetary relief, which obviously is quite rough, and not having contact with children or supervised contact, which can be imposed by the domestic violence court, often abused, unfortunately, often abused. Then SAPS regarding collections of personal property, seizure of firearms or dangerous weapons. Then, very interestingly, the physical address of the complainant's residence not be disclosed to the respondent. This can be ordered. I've found very often the courts don't actually redact it before they serve it. I have, in cases, succeeded on behalf of clients saying, care of my attorneys of record at so-and-so, and then the client, just when they are at court, would just tell the magistrate where they live. Then you can define personal property to be picked up, and then very importantly, you need to state at which police station you will likely report a breach of the protection order. Very, very, very comprehensive form. That is our application for a protection order under the Domestic Violence Act. Then the Domestic Violence Form 12 is very important. This is to apply for setting aside of a protection order. And this, folks, I think, really, it's obvious it deals with the final protection order, not an interim protection order. Interim protection order, your relief is to anticipate the return date and take it. Hendrik asks, how do you enforce a monetary thing? You can issue a warrant in the ordinary course. It operates the same as a civil money judgment. So you can do, you can attach, in other words. Then for the variation, particulars of the applicant, this is generally the respondent in the first application who would ask for it to be set aside or varied. Particulars of the respondent, particulars of when the protection order was granted, and what you want to apply for, and then you have to set out reasons. Now, once again, folks, I mean, this really is not a big space to write in these types of applications. I would surmise that there would be an affidavit accompanying it. Okay, so honorable mention, once we're done with these, I am going to just refer you guys to 2 more documents, then we're done. The first is the Family Advocate Annexure A, and the second is the Family Advocate Annexure B. Now, what is the difference between the two? The Family Advocate Annexure A, and I'm going to share that screen with you briefly, that generally would accompany a divorce summons. In terms of the Mediation of Certain Divorce Matters Act, you have to set out in an annexure your arrangements regarding dependent and minor children. Guys, those of you who litigate frequently, especially in big money divorces, be flippin' careful with this document. As practitioners, we are very tempted to simply say to client, there you go and complete it, and they just thumb suck. And it is absolute fodder for cross-examination. Be very, very careful when completing the Family Advocate Annexure A. Very simply, it is just details of plaintiff, applicant, respondent or defendant, general information regarding the children, and arrangements regarding where they stay, where they'll go to school, etc., etc. So that is the Family Advocate Annexure A. It will be in the pack, which we will be distributing after the session today. And then the Family Advocate Annexure B, folks, this is a different document. This generally is filled in when legal action is already pending, and that is a request to the family advocate to institute an inquiry. So you refer it to the FAO for investigation. This one is signed generally by the attorney for one of the parties. The parties don't have to sign this. The Annexure A, however, is an affidavit that they have to sign under oath.